Welcome to this explainer. Today we're digging into the dramatic and honestly pretty fascinating evolution of a field that, for the longest time, just felt completely invisible. We're talking about the awakening of Canadian legal ethics. We're going to trace its wild journey from a totally forgotten subject, the kind just gathering dust in the back of law libraries, to a dynamic, supercritical discipline that literally shapes how justice is practiced today.
So, to kick things off, let's address the elephant in the room. Is legal ethics just a giant oxymoron? I mean, it's a classic punchline, right? But here's the crazy part. For decades, if you looked at Canadian law faculties and really scrutinized their course offerings, you'd actually believe the joke was true. Legal educators just weren't doing the subject justice. If you were an observer looking for deep, scholarly work on professional morality in Canada back then, well, you would have come up virtually empty-handed. Let's dive in and see just how barren this landscape originally was.
This historic problem was probably best summed up by Supreme Court Justice Frank Iacobucci. He very diplomatically stated that legal ethics was, quote, a subject that is not well represented in Canada. Talk about the understatement of the century. This absolute dearth of interest was frankly hard to wrap your head around. Because think about it, no matter what path a lawyer takes, whether they entirely avoid torts or property or criminal law, questions of professional responsibility are absolutely unavoidable. It's literally the applied philosophy of being a lawyer.
Section 1. The Sounds of Silence.
So, historically, the Canadian legal establishment suffered from the massive staying power of just one single book. If you surveyed the field decades ago, you'd find almost nothing out there except Mark Orkin's 1957 monograph. The establishment basically looked at that and concluded, yep, this one text is perfectly sufficient for the entire country. And that lasted for decades. It completely dominated the landscape, even while every other critical area of law was evolving at lightning speed.
And man, this stagnation just dragged on. As we see here, we start with Orkin in 57. Then, jump to 1974. The Canadian Bar Association puts out its Code of Professional Conduct. You'd think that would spark some serious debate, right? Nope, it really didn't. Then down in the US, the Watergate scandal hits. That unleashed an unprecedented flood of self-reflection in the American legal world, to the point where US law students were actually forced to take ethics courses. But up in Canada, Watergate totally failed to wake up the slumbering legal establishment. The silence just kept on, leaving scholars like Harry Arthurs basically toiling away completely alone in this academic desert.
Which brings us to Section 2, the ethical awakening.
1,000%. Now, I know statistics can sometimes be a bit deceiving, but this one is just incredibly revealing. In a single decade, the 1990s, there was a staggering 1,000% increase in books dedicated to Canadian legal ethics. Where there used to be just that one lonely book we talked about, suddenly there were at least 10. It was like the whole landscape shifted overnight.
So you might be wondering, what exactly sparked this massive explosion of interest? Well, it really boils down to two major catalysts. The first was the 1987 revision of the CBA's Code of Professional Conduct. It sort of became this ethical Esperanto, a common language that allowed different law societies across the board to adopt or adapt the code. It finally opened the door for a true national conversation. And the second catalyst? A landmark 1990 Supreme Court decision called Martin v. Gray.
Martin versus Gray was an absolute wake-up call. The Supreme Court had to tackle this super complex issue of disqualifying conflicts of interest. The case involved a junior lawyer who basically switched sides, joining a firm that was acting against his former client. The court realized that in this highly mobile job market, lawyers were trading firms like fans trade hockey cards. This ruling took all those abstract, theoretical debates about ethics and brought them crashing right down into the everyday reality of practicing law, which led to a massive outpouring of new commentary and guidelines.
Moving on to Section 3, the first generation.
So the books that came out in this first wave, like the ones by Beverly G. Smith and Gordon Turriff, they were mostly descriptive and heavily code-based. Don't get me wrong, they were excellent reference tools if you needed to navigate the new rules, but they strictly focused on the what and the how of legal ethics. They didn't really hit pause to ask that vital, self-reflective question, why? That deeper, more analytical heavy lifting, well, that was left for the next generation of scholars to figure out.
Section 4. A critical move forward.
The real game changer here came from Alan Hutchinson. He introduced the very first comprehensive critique of legal ethics in Canada. Hutchinson came right out and boldly argued that we had to stop looking at ethics as just some quasi set of rules to be mastered and manipulated to get what we want. He called for a massive shift away from just basic professional regulation and instead pushed for profound, deep personal responsibility.
Hutchinson completely rejected that traditional, almost movie-like image of the lawyer as a hired gun. You know, the model where zealous advocacy in an adversary system basically strips the lawyer of their own personal autonomy. Instead, he proposed what he called a political dialogue. Think of it as an open model, where lawyers and clients actually share, learn, and evolve together. They navigate a contextual morality, rather than just blindly subordinating who they are to a rigid rulebook.
But you have to ask, why is it so incredibly hard for lawyers to adopt this new model? Well, to explain it, Hutchinson makes this striking and honestly kind of uncomfortable comparison between legal education and the military. He argues that both are just incredibly strict socialization processes. Law school, he says, basically tries to strip away a student's previous affiliations. It devalues their true diversity and past education just to enforce a highly standardized way of thinking. They learn to conform. They literally learn to think like a lawyer.
So, how do we fix such a deep-rooted issue? His proposed solution is an educational dialogue. Instead of just programming students to uniformly think like a lawyer, law school classrooms need to become open sites for the free exchange of ideas. Whether a student is a woman of color, an economist, an immigrant, or a biology major, they absolutely must be encouraged to think like who they are. This is the essential first step before we can ever hope to achieve true ethical dialogue out in the real world of legal practice.
And that brings us to Section 5, the global context. Now, because there has historically been such a severe lack of empirical research right here at home, Canada suffers from what researchers call an Anglo-American confusion. We're constantly in this tug of war. Do we look down south to the United States for inspiration, or do we look across the ponds to the United Kingdom, where Canadian barristers and solicitors originally got their traditions? Now, relying on foreign sources makes sense, but the goal shouldn't just be copy-pasting their rules. We need to use them to spark critical self-reflection about our own unique domestic values.
For example, by looking at modern scholarship from the UK, we actually get a fantastic roadmap for what might disrupt our own profession next. UK scholars point to some pretty heavy future catalysts for change. Things like the increasing specialization and routinization of legal work, heavy bureaucratization, the fragmentation of the profession as a whole, and, of course, globalization. As lawyers are forced to confront ethical issues on a global stage more and more, it absolutely forces a domestic reckoning right here at home.
And that brings us right back to the core of personal responsibility. I want to leave you with a pretty profound question, drawn straight from this emerging global scholarship. It's a real-world dilemma that strikes at the very heart of what it means to be a modern professional. If professionals fundamentally disagree with the conventional ethics of their profession, what should they do? Should they try to change them? Should they just ignore them? Or should they pack up and leave their profession entirely? Take a second to think about how you'd answer that in your own life. Thanks for joining me on this explainer, and remember to always keep asking why.